Welcome once again to our live webinar. And today's topic, as I mentioned early on, is urgent High Court application in care and custody matters, care and contact matters. Yes, care and custody are basically the same things. And today I'll be discussing the topic on how it is done, unpacking it a bit. You can see on the screen there are some data applicable to the specific topic. And feel free to interact. As I mentioned a short moment ago, you are welcome to pose a question via the Facebook Live platform, Advocate Mohammed Abduroaf Facebook page. I see a question has come in. Wonderful. I shall deal with that after I've unpacked what's on the whiteboard. Or you may call in via the Zoom link, and by doing so, I shall speak to you. No one would see your face. They would only hear your voice, and we can properly interact. If you are watching this video later, please note that I would not be able to, or we won't answer those questions via the chat. It's too much. This video is broadcast on quite a few platforms, a few Facebook pages, groups as well. And the only way I can interact with you would be via the live interface. And that's what we are dealing with now. Therefore, I'm looking at the Zoom page as well, sorry, the Zoom screen as well. If you want to connect, please feel free to do so, and we will take it from there. Let me just change some settings quickly. We can not have any problems later on. Okay, that's all looking good. Let us begin. Okay, wonderful. Many people approach me, or they might approach an attorney, and there are serious issues involved regarding care and contact. The usual query I would receive is the other party is refusing me care and contact to my minor child, or visitation rights to my minor child, to be simplistic. The last time I saw my child was 2 months ago. Before that, I saw my child quite frequently. There were never problems, but since I've gotten engaged to someone else, I am now being limited with contact. The other parent no longer wants me to have any contact with the child. I call, I SMS, I WhatsApp, but to no avail. I am being refused. And I need to see my child. My child, of course, misses me. The child is quite young, they say 5 years old. And I'm being cut off from the child's life for no apparent good reason. What can I do? In front of me, you do not know the law, you do not understand the law, and I will have to find a solution and find a quick fix to your problem. Of course, I'll ask a few general questions. How were you and the mother involved? Were you married? If you were not married, did you live together? When last were you together? The reasons for the breakdown, some general information. I would ask information regarding the minor child. How was contact exercised since birth? Were you much involved in the child's life? If you were not, that's fine, that's all in order. I would like to have a bit of a picture as to what am I dealing here with. Am I dealing with a court order? Has there been a court order in place? If you are divorced, of course there will be a court order in place. Are we dealing with issues of contempt? Has there been any maintenance arrangement in place? Although maintenance and care contact arrangements are not intertwined, they are separate issues, but I need to know, how involved are you in the child's life? Because this all plays a role in the bigger picture. And I will unpack things in the first 15 minutes to understand what am I dealing here with. Am I dealing with a one-night stand? We made a woman pregnant and you came back 10 years later and all of a sudden you like to see your child? Or am I dealing with someone who has tried at least to be very much involved in the child's life, and there's a bond? Important questions. How do you exercise contact with a minor child, etc. So those are the things which I, of course, consider and I look at to have a better understanding as to what am I dealing here with. And by doing so, I'll be in a very good position to advise you, on how to go ahead. If the matter is urgent, I will proceed with advising you on how to deal with it urgently. If the matter is semi-urgent, or you are being afforded contact rights but on the terms and conditions of the other party, then I will look at the matter differently. If the last time you exercised contact at your own behest was, let's say, 6 months ago, and all of a sudden you came back and the child is extremely young, let's say a year old, and now would like to exercise contact, the matter will obviously have to be dealt with differently than with a situation where the child is 10 years old, you've been seeing the child every single day, and all of a sudden contact has been cut. There are obviously other ways of resolving matters. One would be having an attorney. I'm not an attorney, I'm an advocate. Having an attorney send the other party a letter unpacking the issues and basically stipulating that our client would like to exercise contact, failing which we will have no alternative but to approach a competent court, because then the judge can listen to both sides of the story and make a decision. Alternatively, the attorney or parties can go for mediation, and they can sit before a professional person who can assist the parties and advise them on, or assist them at least on dealing with these issues. I always believe, and I do believe that a competent mediator in family matters must have a bit of understanding on family law. Maybe not a bit of understanding, quite a bit more of understanding, not necessarily as much as an attorney or an advocate, but should understand the law, should understand the Children's Act, should understand the Constitution, should understand various cases, case law. And a counselor, mediator that is involved in legal matters from a court perspective, from a court point of view, would obviously have much more insight than a mediator that never stepped foot in a court of law and never ever had to deal with a legal matter. With respect to everyone, I'm not mentioning names, I'm just giving my opinion as to what I believe are the best type of mediators. The same way, a mediator at work, a work mediator that deals with employment issues, he would not be the best suited person to deal with family legal matters. Of course not. And the same way, a family mediator who understands the family law, the Constitution, the Children's Act, various legislation, etc., would not be the ideal person to deal with work conflict mediation. Of course not. Different horses for different courses. That's how it goes. Okay, so I've unpacked the matter. I understand the issues. I've, listened to my client's version, what he or she believes is best for the minor child. We've discussed alternatives. We have discussed mediation, writing a letter. We're of course now discussing the issue of going to court. Now, you need to understand that you can have the best advocate, the best attorney, a lot of money, also maybe not a lot of money. It does not mean that you will be successful in your case. Your case should be well presented, extremely well presented. And when I say extremely well presented, the person drafting your court documentation and presenting your case needs to do a proper job, as in any field, any type of work. You need to do a proper job. I believe that. There's no half-baked legal application, court application. You do a proper job. But at the end of the day, the court will have to make a decision based upon the evidence before it, presented by you in your affidavit and argued by your legal representative, and presented by the other party in affidavit and argued by their legal representative. Obviously, the better your documents are drafted, the possibility of you being successful increases. Because if you draft bad documents, weak documents, where we're dealing with child care and contact, but all that you are focusing on is bad mouthing the other party and discussing the affairs he or she had during the marriage 5 years ago, focusing on that. Clearly, the grammar might be good, the wording might be nice, you might feel good signing this affidavit because now the court can see what bad person the other party was during the marriage. But you've missed the bus. You have not focused on what is relevant under the circumstances in the specific case. Had you maybe have sued the person if there was a possible case for that? Forfeiture of matrimonial benefits based upon him or her having affairs. Yes, then you argue those points. Then you're not going to argue child care and contact issues. But here you are dealing with a child care and contact case. Therefore, you focus on what's important under these circumstances. There are legal practitioners who understand the concept, who understand how to draft this documentation, and there are some that do not. It's very important that you as a client, first and foremost, learn to unpack cases and understand what's important and focus on what is important. I like using the example, you get 40 pages to draft whatever you want to draft. Some papers are more, but let's say 40 pages. Who you are, who the other party is, the child, the history, the problems, what you want, and why you are entitled to get what you want, and support with supporting facts and information. You got 40 pages to do that. Or you can spend 39 pages focusing on irrelevant things. The affairs, as I mentioned now, the problems you guys had as a couple, the bad mouthing, the in-laws, etc. How bad the other party is, you presuming the other party is on drugs, is schizophrenic, has certain mental disorders. Nothing has been ever proved. There's no data to even show that. But you're focusing on that, and then you're expecting the court to make a decision based upon things which won't assist in moving your case forward. Or, as I mentioned earlier on, you draft your documentation well, what data provided in order to move your case forward. I consulted with my client and we've decided, yes, this matter is extremely urgent. We do not have time to send letters giving the other party even 2 or 3 days notice in order for them to respond and consider, because now they respond and they say, no, we're not interested. Then we'll have to file, then we have to draft the urgent application and then approach the court. It will delay matters, because for argument's sake, we had a scenario. In my case here, the father was a primary caregiver of the minor child. He always cared for the minor child, X, Y, and Z. The mother used to have contact every second weekend because she's working and she's not necessarily a fit mom. But few, years ago, they have gone to the divorce court, and the divorce court granted the mother primary care. But that soon changed because the mother found out she cannot care for the child. So for the last 5 years, I might be changing the example, despite a court order, the father took on the role of primary care. Father gets engaged, mother comes to the doorstep and says, whoop, I got a court order of 5 years ago. I have primary care. She takes the child away, the dad maybe goes to the police. The police says, no sir, I'm looking at a court order. The court order says the mother should have the child and you should have the child every second weekend only. Today is Monday, sir. Please return the child. If the police are entitled to get involved. Problems, challenge. What happens now? What does the father do now? Does he follow this long procedure, writing letters, first line to mediate? Or does he have this matter adjudicated upon urgently because the child needs to be with the father? He doesn't know anything about the mother. The mother used to use drugs. She actually used to use drugs, has psychotic problems. She lives in a shady area. Those are the issues the mother has. Should the father first say, I'm first writing a letter. I'm getting a turn to write a letter today still, and give them 2 days to return the child. Well, first time to mediate, knowing full well that the children might be in danger. The child is 6 years old. He's been caring for the child since the child was 1 year old. The mother saw the child maybe once a month or whenever. Does he allow this status quo to continue and first try to mediate or try to resolve this matter? No, you shouldn't. My advice to him is no, you do not do that. Either the mother returns the child immediately to the primary caregiver, you. The mother collected the child is not even at school. You don't know where the child is, but you know where the mother is. What do? You launch an urgent application. You take the case to the court with all the information, with all the data, unpacking your case. And the court will obviously have to make an urgent decision because the child's best interest is at play. Urgent. What do? What do I do now? What does my attorney do? What does the lawyers do? What do they do now? They'll have to draft an urgent application. And I'm dealing here with a scenario where we will be approaching the High Court. and not the children's court. That's a different procedure. You can approach the children's court to fill in forms and they will try their best to assist you. But today's scenario, we're dealing with the High Court. To start an urgent application, the first document you'll have to draft is a notice of motion. I will not be ridiculous in my webinar. I shall not do that. I will not for 1 second presume you are lawyers or you understand the law, you understand these terms. No, I will try to be as basic as possible, as if you are sitting in front of me. And I believe I get better results by letting my clients understand the process. I get many complaints from people who have been dealing with other legal practitioners who do not explain to them the process. Spend 15-20 minutes on a client explaining the process before you as a legal practitioner spends 20-30-40 hours in fighting the case. Important you do that. The notice of motion. The notice of motion is basically a notice to the court or the other party, a piece of document stipulating, I would like to make an application. I'm being very elementary here. If you are an attorney or an advocate watching this video, please note, I'm trying to explain this to the layperson. The notice of motion, simple piece of document, could be complicated. Stipulating basically, I would like to have the following. What are you asking for? I'm asking urgently, Judge, firstly, deal with this matter urgently. I'm asking that I would like to have the following, the immediate return of the minor child to my care, and whatever else you would like to ask. That's what you're asking for. And you're stipulating that in this notice, the hearing date, I'm sitting this matter down for 2 weeks' time, or 2 days' time, or this afternoon, or tomorrow morning, whatever the case may be. You're stipulating that. That's a notice to the other party and to the court. You go to court, the court will obviously know exactly what you're asking for, but we're not there yet. Then attached to this notice, you have to have a founding affidavit. Now, the usual way of providing evidence to a court would, of course, be you go to the court, you swear, you put up your, it's my left hand, but you put up your right hand, and you say, so help me God, and you swear that you will be telling the truth. The court listens to your case, and the court will obviously weigh it and make a decision. In an urgent application, is done via notice to the other party, and you attach it to an affidavit. They call it the founding affidavit. It's the first affidavit, founding. You're founding a case upon. In that affidavit, you explain to the court who you are, who the other party is, who the child is, what you want. You explain to the court what you want, why the matter is urgent. You provide the court with background information, for example, that you've been caring for the child, that the parties were divorced, however things have changed. And you explain to the court exactly why the minor child should be returned to you. So you provide all the background information. For example, you stipulate that the child is now attending school, you're the one that takes the child to school, you attend to the homework, the extra meal, etc. But that has come to an end because the other parent has now taken the child away from you, and you unpack that as well. How did it come about that the other parent took the child away from you? And you unpack all the relevant information. You do not mention that there were many affairs in the past. You do not mention that the other party is, not friendly, doesn't have a nice personality. Your in-laws were horrible people. You do not mention those things. You're wasting your time. You're wasting energy here. You're taking the court's mind away from what's important. You need to keep the judge there. I'm certain many of you have read very good books where the writer keeps you there. Same with some movies. You watch that movie, the opening credits. Movie starts at 8 o'clock in the evening. Next thing you know, it's 20 past 8. You've been focusing so much. The movie kept you on path. So the judge knows. He mustn't listen to affairs and stuff like that. He knows he's looking for something here. You are making an urgent application for the return of the minor child. That's what you are doing. That's what he did. He first reads a notice of motion. So when he reads your affidavit, you need to go there. It's like me reading a manual on how to surf, not surf the internet, surf in the ocean. I'm reading a manual on that. But the manual is explaining to me how to make a cup of tea. Now, am I missing it here? Am I missing on the wrong page here? What am I looking for? Because I'm looking for that section dealing with the surfing part. The same way with drafting High Court urgent applications. The presiding officer, the respectful judge, is looking for those personal information that will assist him in making a decision. He's looking for that so that he can apply his mind to it. All data that applies to the case, he's looking for that. So you focus on that in your founding affidavit, what's important in order for the court to make a decision, an urgent decision, a robust decision, because you are telling the court, I need this child to be returned to me as soon as possible. So that's in your founding affidavit, but the court didn't lead to it yet because you still have to have it served upon the other party. You are happy with the document or the affidavit, you go to the police station, you sign it, fine. It gets attached to your notice of motion. So now the question is this application so urgent that we cannot give the mother notice or the other party notice, any other facts? Or is it one of those cases you need to give the other party notice because the facts mentioned over here could be lies? The court will see it from that possible point of view. It could be, how can I say now, fantasies, lies, not the truth. And therefore, I always advise people, what if you launch an urgent application and it's not life and death, can wait an hour, a few hours, please serve this documentation to the other party. Depending upon the urgency, the proper way would be via the sheriff, but if that is not possible, via WhatsApp, via Facebook, via email. The attorney should do all of that. Or the attorney should quickly get into his car and drive to the other party after he issued this documentation and serve it upon the other party and explain to the court it's urgent. The court will have to say, sir, what did you do? No, my attorney acted urgently, and the court said, yes, you're right, he done a proper job. He should not have waited or first take it to the sheriff, where the sheriff might take a day or two to do that. He done a proper job. The court must be convinced that that was a proper move to have made. Okay, the other party receives the documentation. You're setting the matter down for tomorrow afternoon, for this evening, whatever the case may be. The other party will now have an opportunity to state what he or she wants to state. So he or she will draft the opposing affidavit. So I'm not on anybody's side here. I'm trying to be as neutral as possible here. So let us, for argument's sake, now stipulate I'm the lawyer for the opposing party, for the other side. And let's say, for example, I'm the lawyer for the wife. Now, example. So she receives this documentation via email, via WhatsApp, via sheriff, whatever is applicable. She comes to see the attorney reads the documentation, the attorney says, advocate, I got an urgent application, he contacts me. The matter set down for tomorrow afternoon at 12 o'clock. Now, 12 o'clock as well, 24 hours time. Allegation looks serious. My client came to my client says, no, these allegations are not right. They are lies. She does not believe that the child should be returned. The child should actually be remained with her because the facts mentioned are not correct. I've always cared for the child, but I just went to Johannesburg for a few weeks and I came back, and now the father does not want to give the child. Did not want to give the child to me, but I went to the cops and I got the child back with the court order. So that's my client's version. I'm now the lawyer, the advocate now for the other side, for the mother. What do? I have to obviously draft an urgent opposing affidavit. I'll have to now see, firstly, what is the father asking for? He's asking for the urgent return. Fine, I consult with the client. I get a lot of data I can pick up from the affidavit. Generally, information that is not necessarily lied upon would be their parties were married, they got divorced, a court order. So that gives that fast tracks me a bit, understanding the issues. The nitty-gritty might be disputed, but we all know there's one child, they were divorced, they're not living together. The mother does this, the father does this. That's all mentioned in the founding affidavit. It was properly drafted. I consulted the client. The client says no, the child should not have been returned. We should follow the court order. And that's my belief. That's my understanding. And she explains why. And I have to take what she has to take, what she sees as being the truth and correct. I'll have to draft the opposing affidavit. In my opposing affidavit, I will stipulate exactly what I agreed with. Many other facts, initial facts will be, well, I'll agree upon that the parties were married, they were divorced, the child age, the child goes to school, I will agree to that. But the allegations made by the other party, which I disagree with, for example, that the father always cared for the minor child, that the mother cannot care for the minor child, I will oppose it. And whenever I disagree with something, I explain why I'm disagreeing with that, so that the judge can understand where we're coming from. And then further in affidavit, I can, after I've dealt with all the allegations that were made by the father, I will add my own case. I will explain to the court why exactly the current order should be set aside. I might even have a counter application. I'll get an opportunity to add my additional comments, my additional information to support my argument. So that's basically, I wouldn't call it part B, don't stipulate part B, but that's the second part of the affidavit where I'm dealing with data, additional data that was not mentioned by the father at all in his founding affidavit. Let's say the father does not mention that he remarried. And I'll say, no, he remarried, the stepmother is a bad person. For argument's sake, might be a bit bad example. And then I will deal with that. Now, that documentation gets served on the father's attorney, or him personally, depending upon our service and who's representing who. Now, I put back on my hat now for the father. I'm his advocate. My attorney phones me, advocate, we got an opposing affidavit. Let's deal with it. I go through the opposing affidavit. I see what's in dispute, what's not in dispute. Oh, I see there's a new allegation being made about the father remarrying and the stepmother being a bad person. I'll deal with that. I cannot deal with things which I have already dealt with in my founding affidavit, where the mother denies and she gave an explanation. I do not get a second bite at the cake, as I would say. Whatever new information is provided, basically, I will respond to that. Of course, there are some certain type of possible exceptions, but I'm not here to explain that. I'm just trying to be as general and logical as possible. Okay. Replying affidavit hat on, I draft a replying affidavit. I deal with the new allegations made, and at the end I say I still want what I'm asking for. So the court knows what issues are in dispute. The documentation goes to court. A judge hopefully is appointed in this matter, and the judge will obviously read through the documentation. He will read what the mother says, what the father initially said. What the mother's response to that is, her position, and of course she will read the reply from the father, what the father has to say. If the court, I'm jumping the gun here, now in front of the court, the next day 12 o'clock, Advocate Abduroaf A drafted well for the father, Advocate Abduroaf B drafted very well for the mother, and now the court has to now decide on the matter. So the judge reads through the documentation and he listens to the both legal representatives for either party. So the applicant's legal representative will come and argue, and he will argue and stipulate, okay, judge, we read through all the documentation, but these are the crux of the matter. The child needs to be returned because of A, B, and C. The mother's advocate will speak afterwards and he will say the child needs to be returned because of A, B, C, and D, E, and F. Additional arguments. And then the father's advocate, will stand up again and he will deal with D, E, and F, the additional arguments. You can't re-argue what you would have argued initially because the other party is now opposing it and denying it. Doesn't make sense. If I say the car is blue and the other lawyer says the car is black, and I stand up again, I cannot again say the car is blue. We know it's in dispute. We do not have to waste the court's time by re-arguing points again. The court will obviously have to make a decision, make a robust decision. The court will either one of two things say, okay, worst case scenario, dismiss the application because couldn't prove anything. Or the court will make an order that the minor child immediately return to the father, to his primary care, and maybe vary the court order, or the court might make an interim order stipulating, I'm in the interim giving the child back to the father, and these will be the interim contact arrangements that will be applicable, but I would like to have the family advocate investigate this matter before I make a final order. Whatever the court decides, but the court will be able to deal with the matter on that specific date. Either finalize it in its totality, which doesn't generally happen because the court might want to get an expert on board, but it's possible, it's very possible if all the documentation has been presented, or the court will have to postpone the matter and get an expert on board, but have to make an interim order. Or the court will say, no, I'm leaving things exactly the way they are, I'm making no order, I'm first getting an expert on board. Many things can happen after that, but the court will have to decide what is best under the circumstances. That's it, ladies and gentlemen, on the topic of how urgent High Court applications are made in relation to care and contact matters. If you have any questions, you're welcome to pose them and I shall try my best to answer them. I have a live question. Let me just get to that question. This question comes from an attorney, so I need to deal with it properly. I don't have problems here with an attorney telling me, advocate, I posed a question online and you never answered it properly. Let me copy it quickly and let's take it from there. Please note you have to pose a question on the Advocate Muhammad Abduroaf Facebook page, and you can make use of the Zoom platform as well. The link is above. Just copy and paste it. Here we are. Let us deal with this question, and thank you for the question. I appreciate it very much. The live question goes as follows, and it was posted quite some time ago. Sorry for keeping you waiting. I see I'm speaking now for the last 30 minutes. The question is as follows. The mother has alienated the child from the father since birth. Okay, so the child was born. Father was not allowed to have any real contact with the minor child. Alienation took place. The child is now 15 years old and the father still wants to have a bond with the child if possible. What can the father do, if any, to achieve this? Very interesting question, and thank you for it once more. Alienation, we're not here to discuss that, but it's not a good thing to alienate a child from the other parent. There are many reasons for that. One could be because of how the breakdown took place, or sometimes the father is involved with someone else, maybe he's married to someone and he makes his girl pregnant, and child pops up and he decides now to continue with this other person, and those are hurt issues. The father, of course, is the biological parent, and if anybody has a say over the child's life, it will definitely be the mother, or the father possibly, if he has parental rights and responsibilities. A father can acquire it by trying to be involved in the child's life, perfectly fine. But 15 years is quite long, and the question obviously will be posed as, why did he wait so long, 15 years? I mean, he should have approached the court some time ago, but that's not for me to judge or to stipulate. There is a question, and it needs to have a good answer for that. But an honest answer, of course. But it's 15 years later, the child does not know the father. My advice to the specific person would be, the best way to deal with this matter would be obviously to make an application to court. The court will have to make a decision as what is best for the minor child, despite the surrounding facts. It is possible that a child who has never seen the father or been involved in the father's life for the last 15 years would benefit from having a father. I think those are the facts. So I must probably advise the party first to go to an attorney. It's a very sensitive issue because here we're dealing with a 15-year-old child. And the law considers greatly what the minor child wants at that specific age. A 15-year-old child is mature. He or she had to maybe deal with not having a father in her life or his life for the last 15 years. It might be better for her not to get involved with his father, because psychologically she dealt with that. She might have gone through counseling, and all of a sudden the father wants to get involved in the child's life. I would advise maybe first send a letter to the other party in a very nice format. The father would like to be involved in the child's life. If the other party maybe agrees and says, okay, no problem, we can maybe have some type of supervised contact, up to the child. Maybe approach a social worker, a psychologist, try to mediate and intervene between the matter. It has to be very sensitively done. That is another option you have. If, for argument's sake, nothing happens and the mother is adamant you cannot have contact, do not approach the child directly. That's a bad idea, because the child doesn't know who you are. Then, unfortunately, you'll have to approach the court, Jonas Court or the High Court. I wouldn't say a matter like this is necessarily urgent, but at the same time, if you maybe follow the long format and a long way of dealing with this matter, it might be finalized in a year or two, possible, and then the child is 17 years old. So, in my view, it could be urgent because 15 years has passed. It depends how you argue the matter. But it needs to be done very sensitively. I've dealt with a similar matter in the past where the child is 13 years old, where the mother had the child 13 years ago, and the father wasn't involved in the child's life at all. The mother married someone, and the child believed that this man that my mother married is my father. So that continued for 13 years. 13 years later, the father came and he says, I would like to have some contact with my child. Fine, he has full right to do that, and I respect that. I mean, the child needs to know who the biological father is, which you will find out. Facts are the facts. We are where we are. If the father decided to stay away, that's the facts. But he came to the table. And we got a social worker on board, etc. And the social worker consulted the child. The child said, "No, I do not want to be involved in the father's life. I do not want to know the father. I do not want to meet with him." What could we do? We can't force the child. The child is a very delicate stage. Ultimately, I believe at some point the child would, if the father persisted, you would have had to have contact. The court would have had to make it happen at some point because he is a biological father. But the father was sensitive, sensible, and he decided, okay, to step back. I think it was a good idea for him to have done that because it was a lot of data for the child to have, processed. All of a sudden, this man I'm living with is not my father. But she was fine about that. Maybe a few months later, well, not necessarily before the child is 18, maybe when the child is 18, things will be different. It's a process. That's where I'm going to. Obviously, you can't approach a court if the child is already 18 because then the child is an adult, no longer a child. I hope that answered that specific question. Sensitivity is very important. These are serious things. But I would love, in any situation, no matter what the facts, if the father was a drug addict, whatever, and he comes back 17 years later and wants to be involved in the child's life, I think it's important. It's unfortunate, but I think it's important. Ladies and gentlemen, that's my webinar for today. If you have any additional questions, you need to post it very quick. Otherwise, I think we've done well today, and I hope to see you online soon. Have a lovely weekend. Be safe, and no, sorry, it's not a comment. Be safe and look after yourself. Thank you very much.